Welcome to the deep dive. Today, we're tackling, well, a really significant area. Modern mental health laws, right here in Australia.
Yeah, it's a complex topic.
Definitely. Think of this as your express route to understanding how these laws operate. Everything from compulsory assessment and treatment, even things like ECT.
Right. To patient rights, carer rights, and the role of those mental health tribunals. They're crucial.
Absolutely. These laws really set the stage for our whole mental health system.
They do. They cover things like seclusion, restraint, even forensic psychiatric care. But for this deep dive, we're really zeroing in on the laws allowing compulsory treatment.
And the debates around them.
Exactly. Especially with the Convention on the Rights of Persons with Disabilities, the CRPD, really influencing things now.
Right. That forensic side, the criminal justice intersection. That's huge, but maybe for another day.
Yeah, let's keep the focus tight today on those civil laws, treatment without consent, and the human rights questions that are popping up.
Okay, so to really get where we are now, maybe a quick look back. Our sources talk about this sort of pendulum swing in mental health law.
Yeah, it's a useful way to think about it. Swings between, say, medical power and legal controls, or institutions versus community care.
And there was this big shift, wasn't there, back in the 60s and 70s?
Oh, absolutely. The civil rights movement really brought a sharp critique of those big institutions.
Yeah.
There was real concern about unchecked medical authority. I think one flew over the cuckoo's nest, that kind of cultural vibe.
Right, that definitely captured something. And that critique, it led to, what, rights-based laws?
That's the term used, yeah. The idea was to find a better balance, protect individual rights, but still have ways to support vulnerable people.
So how did they try to strike that balance in practice?
Well, the main thing was embedding medical discretion within sort of legal safeguards, clear rules.
Okay.
So the biggest safeguard became the specific criteria for involuntary commitment. You couldn't just commit someone easily.
And in Australia, what are those key criteria generally?
Yeah. Usually it involves having a defined mental illness that needs treatment and a risk of harm to self or others.
Risk of harm, okay.
Plus, there's this principle, the least restrictive alternative, always aiming for the mildest effective option.
Great, the least intrusive way. And to oversee all this, you mentioned tribunals.
Mental health tribunals, yes, they're set up as these oversight bodies.
How do they typically work? Are they like courts?
Not exactly like courts. They usually have a mix: legal people, psychiatrists, community representatives. They act more like investigators, gathering information to make decisions.
Okay, so a panel trying to get the full picture.
Pretty much. Their exact powers vary, but the goal is oversight and applying those legal criteria.
Now, these rights-based laws, they sound like an improvement, but were there unintended consequences? The sources mentioned deinstitutionalization in the 80s and 90s.
Yes. That move away from large institutions, while well-intentioned, it get linked to problems: displacement of people with complex needs, homelessness.
Almost, yeah.
The source even uses that stark phrase, madness in the streets, talking about the U.S. experience particularly. It shows the challenge of community support.
So the system struggled to cope outside the institutions. And the response wasn't to go back, but did the rules change again?
Sort of. Instead of just immediate risk of harm, criteria in many places expanded to include a risk of deterioration. If someone's health might seriously decline without treatment.
I see. And community treatment orders, CTOs, were they part of that?
They were introduced as a kind of safety net, supposedly, to manage people in the community.
Controversial. Our source flags some criticisms.
They have been, yes. Critics say they can lead to unnecessary intervention, sometimes make it harder to get acute care when needed.
Really? How so?
Well, the argument is they might discourage people from seeking help voluntarily, fearing the compulsory aspect, and importantly, the evidence showing clear benefits internationally. It's not that strong, according to the sources.
So effectiveness is questioned. Okay, so we've got this evolving legal picture, and a really key point you flagged earlier. It's not one system across Australia, is it?
Absolutely not. That's critical. Mental health law is state and territory business. So we have 8 different sets of laws.
8 different acts, wow.
And they can differ quite significantly. Plus, as we said, current reforms are really being shaped by debates around the CRPD.
Okay, that sets the stage nicely. So let's dive into the specifics now. The sources say the crucial standard is the scope of involuntary detention and treatment. What shapes that scope?
3 main things, really. First, How mental illness itself is defined in the law. Second, the exact treatment criteria that need to be met. And third, how that least restrictive principle gets applied.
Right. Let's start with defining mental illness. That's the gateway, isn't it?
It is. And while every state requires a mental illness, they don't all define it the same way. There are variations.
And interestingly, the definitions often list things that are not mental illness, legally speaking.
Exactly. Things like political beliefs, religious views, sexual preference, or just engaging in illegal acts on their own, those are usually specifically excluded. It stops the law being misused, basically.
Makes sense. Distinguishing illness from lifestyle or belief.
Hmm.
Now, besides mental illness, some places have other grounds for compulsion, like mental disturbance or complex cognitive impairment.
Yes, New South Wales and the Northern Territory are examples. NSW uses mental disorder for situations where someone's behavior is so irrational it suggests a temporary need for care to prevent serious physical harm.
Okay, so behavior-focused in that case.
And the NT has complex cognitive impairment. That covers things like intellectual disability or brain injury, leading to, say, reduced capacity for self-care or decision-making. It potentially widens the net beyond just a diagnosed mental illness in those jurisdictions.
Really different pathways to compulsory care. Now, the treatment criteria.
Right.
What generally needs to be shown for treatment to be mandated?
Broadly, that treatment is needed to prevent harm to the person or others or to stop significant deterioration. But here's a key detail. The level of harm required isn't uniform.
The threshold varies. How so?
Well, some states like ACT, NSW, Victoria talk about preventing serious harm. Queensland ups it to imminent serious harm. Western Australia uses significant risk of serious harm. South Australia has its own wording, too.
Those sound like subtle differences, but I guess they could matter hugely in practice.
They absolutely could. It sets a different bar for intervention. Then there's the least restrictive requirement. Sounds simple, but maybe isn't.
Well, the phrasing varies, and there's no single definition across the board. But the core idea is use the gentlest effective approach.
Okay.
The source mentions a case, SV Southeastern Sydney, where oral medication was deemed less restrictive than injections. That gives a concrete example.
That's helpful. It shows it's about practical alternatives. And Victoria's law seems quite specific here.
Yes, it explicitly says decision makers have to consider the patient's views, their advanced statements, input from nominated persons. It emphasizes patient preference more directly.
Interesting. Now, another big element in some states, capacity. What does that mean here?
In places like Queensland, Tassie, the NT, and WA, before involuntary treatment, there needs to be an assessment that the person lacks the capacity to make that specific treatment decision themselves.
Okay, so capacity is a hurdle. How is it defined? Like, what does lacking capacity involve?
Generally, it's about being unable to understand the relevant information about the illness, the treatment, risks, benefits, alternatives, consequences of refusal, and then being unable to weigh it up and communicate a decision. Queensland and WA have detailed definitions along those lines.
And the NT has something unique about refusal.
Yeah, the NT includes having unreasonably refused the proposed treatment as something that might indicate lack of capacity in certain situations.
Unreasonably refused. That sounds potentially subjective.
It could be. And then you've got Victoria, which interestingly doesn't have that explicit capacity requirement in the same way. An authorized psychiatrist can make treatment decisions there even if the person technically has capacity but doesn't consent.
Wow. Okay. That's a fundamental difference in approach.
Definitely highlights the state variations. Finally, on definitions, what about treatment itself? How is that defined?
Generally, it's about using professional skills medication, counseling, therapy to remedy the illness or lessen its effects. But again, there are nuances.
Discuss.
Some states exclude specific things. Tasmania, for example, excludes psychosurgery without consent, termination of pregnancy, sterilization under its Mental Health Act treatment definition. Victoria excludes certain special procedures and research, too. They need separate, often stricter consent rules.
Right, acknowledging some interventions need higher safeguards. Okay, so that covers the sort of nuts and bolts of the current laws. Now let's shift to human rights and the CRPD. Its goal is?
Broadly, to ensure people with disabilities enjoy all human rights equally, without discrimination. It stresses participation, dignity, autonomy.
And Article 12 is key for mental health law.
Absolutely pivotal. It's about equal recognition before the law.
Meaning?
It says people with disabilities have the right to be recognized as legal persons and, crucially, enjoy legal capacity on an equal basis with others. The right to make their own decisions.
Equal legal capacity.
Yeah.
That sounds like it clashes with traditional approaches like substituted decision-making.
It does, fundamentally. The UN committee overseeing the CRPD considers substituted decision-making, where someone else decides for you based on best interests, as incompatible with Article 12.
So the CRPD view is people should retain control, even if they need help.
Exactly. It's not saying everyone has capacity all the time, but that their legal right to decide remains. The focus shifts to providing support to help them make decisions.
Support and the presumption of capacity.
Right. Assume capacity unless proven otherwise. Don't just assume incapacity based on diagnosis. And provide the support needed help understanding info, weighing options, communicating choices. There's even research, like the MacArthur studies, suggesting people can retain capacity even when acutely unwell.
And reasonable accommodation, how does that fit?
It's about making necessary adjustments so people with disabilities can exercise their rights equally. In this context, the idea is that presuming capacity and providing support are the reasonable accommodations, limiting the need for compulsion.
Okay. And Article 12 also requires safeguards when support is provided.
Yes, very important. Safeguards against abuse or undue influence. Things like respecting the person's will and preferences, avoiding conflicts of interest, ensuring measures are proportionate, time-limited, and subject to independent review.
Given all that, it seems there's a real tension between the CRPD principles and current Australian laws.
There certainly is. The laws face criticism for relying on those substituted decision-making models. The UN committee has actually recommended Australia repeal laws allowing interventions without consent and compulsory orders, including CTOs.
So the CRPD is basically pushing for the same standard informed consent that applies in general health care to apply in mental health care too.
That's the core push. Challenging the idea that a mental health diagnosis automatically justifies overriding someone's right to refuse treatment. It calls for respecting autonomy.
And the verdict on current Aussie laws, according to the source.
Largely inconsistent with Article 12 because they still heavily feature substituted decision-making. Plus, there's generally a lack of comprehensive laws for supported decision-making.
Are there any signs of change? Any moves towards the CRPD model?
There are some positive steps. Victoria, Queensland, the ACT are starting to recognize advanced directives or statements, introducing nominated person schemes, mental health advocates.
So some mechanisms emerging.
Yes, but the source suggests they're still developing, and we need a more consistent nationwide approach that truly aligns with the CRPD's vision of equal legal capacity.
This has been incredibly illuminating. It's such a complex area where law, ethics, and human experience collide.
It really is. And it leaves us with that profound question, doesn't it? How do we as a society balance protecting people experiencing severe mental illness with upholding their fundamental rights, autonomy, self-determination? What does a truly rights-respecting mental health system actually look like on the ground?
A question that definitely needs ongoing thought and action.